Thank you so much. Thank you, everyone, and thank you for having us. I think the IPR Gorilla deserves the biggest round of applause. You've been thanking everyone since morning.
Thank you so
I
much.
think Mitali, Jess, Sonia, and everyone I've dealt with under your leadership, Mitali, you've done a fantastic job, and I think help
Thank
me
you, Hala.
give them a big round of applause.
Thank you so much. Thank you for your valuable work.
Thank you for having us. And actually, I'm thrilled to be surrounded by fantastic talents. I've been stalking you for the past week over LinkedIn to know more about you, and it's fascinating. So I'm surrounded by great experts, and we hope during this panel we will answer as many questions as you have. Without further delay, our panel for today covers data privacy, intellectual property, technology ethics, and IP issues. So many, many topics. However, we're going to condense them all around the data privacy and data protection topic and what's the impacts on that. So as you can see, everything with the digital transformation, everything is digitalized, whether our journeys, whether our photos, whether our phone calls, whether our purchases, or even our heartbeats when we go to any hospital or do any medical checks. Also with that, our personal information more and more are collected, stored, and traded by the government and companies and all over the place. In parallel with that, we're having lots of regulations, whether international regulations, whether local regulations, trying to cope with all these digital transformation, which we are facing on day-to-day basis. And yesterday, actually, we had a similar panel with Forbes, and someone called it the data privacy paradox, which I loved it. It is a paradox. Without further delay, let's start with Antonius, with your great expertise in Indonesia and the UK. What you can tell us about the data protection laws there in Indonesia and UK, and how do you feel that GDPR is impacting the local regulations?
Well, thank you, Hala. So, what the interesting point about the data protection and data privacy is, the data is the asset of the company, of the organizations. Lastly, in Indonesia, it's related to data protection and the political power, which is where you know the data of your individual, when you know the behavior of the individual online, it pretty much, you will know about the political point of view of the user as well. So in some point of view, the digital data and the political point of view, it's really sensitive point that we have to protect about the data. In Indonesia, like the population of Indonesia, 270 populations. Most of Indonesian now using, I think, the smartphone. They doing online. They're using a lot of social media, and some of the organizations as well. They analytics the data of the users. I work for the technology company Telkomsel. Is the major player in Indonesia. The shareholder of Telkomsel is Telkom Indonesia and Singtel. We're managing 170 million users of data, and if you can imagine how you protect the data of your user, and how you make it keep confidential of the user, it is I think you have to know the legal basis how to process the data, because if can misleading the data, it can lead to be, you know, for the political party or for the person of the people want to gain the data for their bad intention. And I think that is the important point, that if you store the data, it means that you have to protect your data legally. And then the other point that we have to know about the growing issues. As we know, the GDPR is the most comprehensive data protection regulation on Earth. And some of the countries in this planet looks at the GDPR because in the GDPR they have the extraterritorial jurisdictions, meaning that every European country is also protected by law. On the other hand, in the Southeast Asia countries, in Indonesia, in Singapore, in Thailand, in Philippines, they also have their local data protection issues. In Indonesia, we look at the GDPR as our benchmarking. However, I might say that in Indonesia, the law is more heavy than GDPR because in GDPR there is a penalty 2% global turnover. But in Indonesia, not only the penalty, but also there is a criminal sanction up to 6 years jail. So for the external lawyer like Ashutosh and the other law firm in Indonesia, you may sell as a sweetener if you don't comply with the data protection. Your CEO or your director will going to jail. So in that aspect, I see that GDPR have their influence in several territories and regions.
Perfect. So we can see that actually I've heard before that Indonesian IP laws in terms of enforcement are stricter. Now you're confirming that. I thought like who was telling me was just telling me that. That's awesome. That's actually awesome to see that. And moving to South Asia, to India, Ashutosh, you deal with Indian regime on daily basis. What you can tell us about data protection Indian regime?
In India right now, we are in the stage of transition. So we had till now what we call a sectoral model, where different sectors have their different regulation to regulate the sharing or processing of data. But now taking some inspiration from GDPR, we are moving towards a comprehensive legislative model where we are in the process of, actually it's drafted, it's tabled before, it will be tabled before the parliament next month. And hopefully by the end of this year or maybe early next year, we'll have a comprehensive data legislation in our country. The existing model as of now, as I said, there is a specific sectoral model. Different sector, like for example, in telecom sector, the telecom regulatory body has their own regulation where they say that their service provider will have to follow some guidelines or some rules in order to deal with the data of their subscriber. Same goes for the medical field, where the Medical Council of India has some professional ethics for their doctors, how to deal with the data of their patients. However, this is not a comprehensive model, and the kind of data generation or creation is taking place in India because we have a huge population, and as far as the access to technology is concerned, is also increasing day by day. As Antonius said about the Indonesia, same thing is in India. India is the second largest telephone market in the world, and the smartphone access, people are getting more and more access to smartphone technology, and that is leading to generation of data. So that plus, as Dr. Ahmed mentioned in the morning, that in 2018 we had a landmark Supreme Court judgment, the constitutional bench judgment, where the Supreme Court declared that right to privacy is actually part of fundamental right in India. So once it is declared that right to privacy is a part of fundamental right and part and parcel of Article 21 of the Constitution of India, then you can breach that privacy only in accordance with the procedure established by the law. That's the mandate of Article 21. Right now, we don't have that comprehensive legislation. So now it's actually compulsory for the government or for the parliament to come up with some laws so that they can regulate this sharing and processing of data across the industry, not only to some specific sectors. So the bill is before the parliament. There's some highlight of the bill which I'll just mention. For example, the proposed legislation provide for establishment of data protection authority like we have in GDPR. Same, plus along with that, appellate tribunal, which will deal with the data-related dispute. Apart from that, it recognizes 3 stakeholders in this sphere of data privacy issues. Okay. One is data fiduciary, which is equivalent to what we have data controller in Europe, in GDPR, the company or the organization who is collecting the data. Second is data processor, who is the body who is processing the data. And third, and the most important, is data principal. In Europe, you call it as the data subject, we call it as the data principal. So data principal means us, who are contributing to that generation of data. So the proposed legislation defines the rights and obligation of all these three stakeholders. And most importantly, cast an obligation on the data fiduciary that you have to process the data in fair and reasonable manner, which is very much similar to what GDPR mandates. Apart from that, the most interesting feature of this proposed legislation is, and I think this is something on which the Parliament will debate, and if they won't change it, then hopefully the court might interpret that provision, is that in case of a breach, I'm not sure about the GDPR, but in some US laws, especially the California Consumer Protection Act, that's cast an obligation on the data controller to share that information about breach both with the authority as well as with the user, the data subject. But in India, our proposed legislation says that in case there is any breach of data privacy, then you have to only inform the authority, and then the authority will take a call whether to inform the data subject or data principal or not. Now, this is very interesting because the most affected party is the data principal.
Yeah.
Their right is getting affected. And the preamble of the act starts with that it's about the interest of the data principal to ensure their right to privacy and everything. And at the same time, they don't have that right to get the information whether their privacy has been breached or not. So I'm sure, hopefully, the Parliament will debate this and they may clarify this. Or if not, then
I hope so.
I can see there's some scope for lawyers.
Yeah, I hope so. I hope so. Actually, this brings me, it's very interesting, the combination we have over the panel. We have legal expert and we have the practical data protection officer with us, Beatriz, which is awesome to have you. So after hearing all these regulations and the complexity of regulations and strict enforcement, things to debate and change in India, how do you maintain data protection within your organization? And do you feel like awareness and education plays a role in that?
Well, first of all, I'm happy and very glad to hear that the GDPR is an inspiration for all of you.
They have gone one step ahead. They're making it criminal.
From a European point of view, I can say that it's one of the most challenges regulations right now, and mostly because the European will not be, we didn't get used to work in a proactive way as many other legislations. We used to work in a reactive way. We do things because we have a law which states that if we don't do it, we can be fined. So from a European perspective, it's so hard for us, and it's a challenge to implement the GDPR itself. As all of you mentioned, I'm fully dedicated on privacy matters. I just lost my legal background a couple of years ago. So yeah, one of my challenges in my day-by-day basis is to implement and maintain the privacy framework around 15 branches of NEC technology, which is my Japanese, which is the Japanese company. Different approaches, it depends on the company. I think if you follow a centralized model, it's much more simple to comply with the GDPR requirements. But of course, even though the GDPR is a regulation, you have 27 member states that allows to adopt supplementary rules, even stricter. Right, so there should be always a balance. Yeah, you have this centralized model, but you have several countries which are saying different things. So to me, and from my personal experience, one of the challenges of maintaining a privacy framework is the data flows, how you maintain all the processing activities within the company. I think it's quite challenged because, of course, it depends on the sector and the company, but mostly European companies start doing spreadsheets, trying to get as much as information as we could, But after 1 year and a half, that is not working. So we need to test and start working with providers in order then to allow privacy management tools and be able companies to track all personal data around the company. And critical and so important, it's the awareness. Even though privacy was existing in Europe for many years, I think there is a lack of awareness. I don't really think that companies was invest on privacy matters. So today, I think for European companies are invested a lot of money on training and cultural awareness. I think that privacy has to be on the top. It has to be embedded on the privacy strategy of companies. You need to engage the different stakeholders and top management of the company. If not, the privacy framework is not sustainable.
Yeah.
But yeah, training is critical.
Perfect. Thank you, Beatriz. Thank you. So recently, we're starting to hear this terminology. Whenever we say code of conduct, we used to say business ethics. Now these days, in addition to business ethics, we're hearing technology ethics. Also, we're hearing this terminology whenever we hear data protection or artificial intelligence, everything related to cyber. There's technology ethics, a terminology which is just popping up these days. How will we maintain technology ethics, Antonius, within our organizations?
Well, so as I mentioned, I work for the telecommunication company that transformed to be a digital company. It means that we have several services, not only telecommunication and data, and SMS, not only voice and SMS, but also we create another division called Artificial Intelligence Division. We create Big Data Division as well, Internet of Things. So in those new business, we generate a lot of digital data in our country. 170 million users, of course, compared to China or India, it is nothing, the population. But if we compare to the continent of Australia, which is more or less 25 million users, and I work in a company who managing 170 million users, and also a lot of privacy lawyer, a lot of human rights lawyers, because of privacy is also related to the universal values, which is the human rights. So I really managing the digital data in our organization really carefully. So what I did is, first of all, I made, of course, in every agreement that we have partnered with our vendors, with our partner, I have to check the agreement before we, of course, we're doing the non-disclosure agreement. In agreement, I make sure where the data is located, because it's really critical when the data is stored outside of the territory of Indonesia. Yeah. Based on the prevailing rules and regulations in Indonesia, the critical data should be in Indonesia. I think it's similar what Professor Tabrez Ahmad mentioned in his speech, that the data localization in India also exists. So it's similarly in Indonesia also exists the data localization specifically for the critical data. On the other hand, for the business data, for the commercial data, somehow we can store the data outside of the territory of Indonesia. It is a new law in Indonesia, and I also advised to the Ministry of Communication and Informatics of Republic of Indonesia to to make a more friendly regulations for the company who wants to flourish the business, who wants to promote innovations. Because in my point of view, and also I also published several articles, and I wrote my thesis about the digital data. In my point of view, the regulation should not be a blocker. We know that the digital data have a lot of potential, particularly for the company who have several services, such as Internet of Things, machine learning, and etc. We know the potential of those new technologies, and the law in Indonesia doesn't want to make a blocker. It means that, yeah, of course, in my company, I check every agreement. I make sure where the data located, and also I make a data protection impact assessment within the organization as well. It's kind of like the data protection audit in our company. I make the data protection culture and awareness in several cities of Indonesia. I made in Jakarta, I made in Bali, I made also in Singapore, because our shareholder also come from Singapore Telecom. Other than that, I find it challenging as well in the area of technology ethics, because the technology is evolving, and then in every month I believe there always be an innovation, and there will always be an innovation around us. So several months ago, I discussed with the co-founder of the facial recognition company, because I did the IP consultancy as well, not only the work for the head of digital business compliance in Telkomsel. I met with him that he asked whether if his company can recognize the face of the citizens in Indonesia, is it violate the law or not? So I'm fully understand that this kind of technology may be, and I believe it will be secure the national securities. For example, if you can recognize the people that you are searching for, and you can make an agreement with the Interpol and something like that, you can find the bad guy easily. So it means that the technology help us.
Yeah.
But on the other hand, it hamper our privacy values as well. We don't want to be recognized by the machine. If we walk to traveling in Indonesia, I'm not really comfortable if I work in Indonesia and I'm traveling to London and traveling to Austria, let's say, and then there is a CCTV catch my face, and hey, this is Antonius. He's the lawyer, and then he managing 170 billion users of the data. Of course, it's not really confidence for us. Again, the balance between how we flourishing a new technologies and then keep the privacy within the individuals is a key. That is my point of view.
Yeah, that's actually a very critical point, the fine line between both of them. Yeah. Thank you, Antonius. Actually, you mentioned data, you mentioned an example of the data being localized within Indonesia. And this is actually critical to many regions, and I'm keen to know about India, Indian regime regarding data localization and restrictions you have to transfer data outside India.
Yeah, we are facing a lot of criticism for this.
Yeah.
There is a general impression that India is kind of adopting a very strict regime when it's come to data processing or data transfer outside.
Sorry, can you?
Sorry, am I audible?
Yeah.
Yeah. So, no, I was saying that there is a general impression that India is a very strict regime when it comes to data, transfer of data globally or outside India. However, even in the proposed legislation, in the existing legislation, barring few sectors, especially the banking sector, where there is a strict mandate by RBI that no data can be transferred, or no data pertaining to an Indian citizen can be transferred outside India, there are provisions which allows transfer of data globally, subject to satisfaction of certain condition. For example, that particular country will have the same kind of adequate protection for the data privacy related issue, plus you have to take consent of the data principle. However, in the proposed legislation, there are certain strict criteria only, and that proposed legislation defined data into 3 categories. One is personal data, one is sensitive personal data, and third is critical data.
Okay.
So the Act defines personal data and sensitive personal data, but it doesn't define critical data. It gives that discretion to the government to come up with some notification and define that critical data and puts any data into that category. And when it comes to critical data, it's totally no transfer. The only exception are medical emergency. In that case, the data can be transferred. When it comes to personal data, it can be transferred if, for example, in case of group companies, if they have intra-group schemes, which will have to be approved by the authority. In that case, the data can be transferred among those group companies.
Okay.
And in case of sensitive personal data, apart from having that approval by authority on your inter-group scheme, you will also have to take consent of the data principle.
Yeah.
So these are the 3 different kind of data which which the proposed law will regulate, and there are certain conditions after satisfaction of which data can be transferred. So that general impression is not entirely correct that India is 100% data localization favor, but yeah, there are certain enabling provisions which will enable the transfer of data globally.
Perfect, perfect. So we've talked about data localization, data flow, data ethics. I'm interested to know about the original part of collecting data, how data collection can impact data protection.
Well, I think that's the main core, right? I think that anytime companies collect personal data of individuals, I think that we need to take into consideration the 7 principles under the GDPR. So we need to follow up the life cycle of the data in order to make sure that we are putting in place all the technical measures or any controls in order to mitigate the privacy risk in each particular data collection. So to me, it's also important the way or the source companies are collecting personal data. So it's not the same if you are collecting directly from an individual, right? I think that we are already, in Europe, it's clear that companies needs to be much more transparent and that we need to be clear when we are collecting that personal data, but I don't really think it's so clear still when companies collect personal data from other sources, whether from the individual. And there are so many cases right now that third companies are collecting personal data from websites to profiling individuals or for tracking or for doing like a profile of behavior. And this is still unclear, even though the supervisory authorities in Europe are not giving us a consistency approach. So just for give you an example, we have a huge problem right now with the cookies and the consent, which is not only primarily focused on the GDPR. We are waiting for a new law, a new regulation, I hope at the end of the year, let's see. So there is no any consistency between all those supervisory authorities. And if you go through those guidelines, they are not similar.
Yeah.
So it's quite a challenge right now. It depends on the source of where you are collecting personal data.
Perfect. Thank you for the insight. Thank you. I think we're running out of time, right? How many minutes we have?
5 minutes.
No time, I think.
Okay. I'm not sure where Mitali or Sonia, because they told us, okay, let's open it to the floor, because from 7 minutes, I think we had 10 minutes. So I'm assuming we still have 3 minutes. Anyone has any questions?
There's someone in the back.
Mitali, please, can we give the microphone to, yeah, thank you.
Hi, my name is Nishant, and I have a question for any of the panelists, actually. The question is with respect to some experiences on-ground difficulties with respect to GDPR sort of providing for the contract between the controller and the processor and sub-processors to be governed by union law. Now, for example, our firm represents a couple of financial institutions, and these financial institutions, among a lot of other subscribers and members, also provide services to European Union residents, so to say. Now, how do we mandate a financial institution based out of India, let's say, to have contractual arrangement with their data processors where the contract is governed by a European Union law? I mean, because in general, when you deal with a processor based out of India, the controllers based out of India, you're talking about data for millions of people, out of which a few subjects could be based out of the European Union. How do we actually implement the so-called Article 28 of the GDPR, which mandates contractual arrangement being governed by European Union law? I'm not sure if the question's clear.
Well, the question is clear, but I don't really have the answer for you. My personal experience, I also deal with other non-European countries, right? I've just only try always to cover Article 28 of the GDPR, right? And doing like back-to-back contracts with also processors and so on. But I understand what you're saying. It's so difficult and it's challenge, yeah.
If I can add to this, I cannot answer from the perspective of GDPR because that's not my expertise. But yeah, from a very contractual dispute point of view in India, in any contractual dispute, if that contract has a clause where the governing law is of a foreign jurisdiction, then the Indian court will implement that contract or will decide that dispute in accordance with that law. And there you might place on record expert evidence or some expert from that foreign jurisdiction to depose on the legal aspect of that law. So that's something which, if I think...
Yep, sure, I understand that, Ashutosh. The only concern is for a few subjects, GDPR mandates us to change the applicable law from, let's say, a preferable law to European Union law, otherwise it's in violation of GDPR. That's the conundrum that a lot of the multinational companies, financial institutions, telecom sector is feeling the heat because how do you change the governing law based on, let's say, few subjects being based in the European Union, and let's say 80+% of the subjects are in their local jurisdiction, right? And then you're talking about controller and processor contract being governed by European Union law just because you have European subjects out there. So that's the conundrum that I was trying to understand if anybody has experience as to how that is dealt with, or how can Article 28 be effectively harmonized with general contractual practices in each country.
But it's also, you have to take into consideration that the GDPR is a risk approach law. So it's always that companies need to take into consideration this balance test. Is this really something that is going to harm or cause any damage to individuals? Can the company assume the privacy risk if we are talking about 5 data subjects? So maybe it's a it's a cost effective for only 5 individuals coming from the European Union. So this is something that also companies need to take into account when dealing with the GDPR. It's not always black or white. There's always a gray area and risk approach. And as far as you can justify and you can evidence and justify and document what you are doing, I think from now, it's okay in Europe. From now.
The law is in a state of flux,
Yeah.
so we
Sure,
can't
thank
say
you.
anything.
Any other questions?
Can we have more questions? There's one more.
The lady.
Hi everybody, this is not a question, it's just an observation or something related to what Antonius mentioned on facial recognition, on the data privacy or personal breach of privacy. So this, what I noticed, this is my personal experience by the way, I deactivated my Facebook account 3 years back, but still on the basis of the data or my other photographs or something available on Facebook, Facebook automatically tags my face whenever a photograph, a group photograph where I am, and it tells about my whereabouts. Is this a privacy breach? And how does this, if we write to Facebook, they say you have consented this. So consenting means you give away your rights, or how does it like, how to hold back your privacy rights in that case?
Okay.
From
Well, that is interesting question. Thank you. I'm not mention Facebook is violate the privacy. It can be happen in any organizations in this world. So when we talk about how to managing the data, we have to talk about how to take care of the human rights values. That's what I have in mind. Even though I work for the company who pursue the profit, I'm also aware that I don't want to mislead the digital data of our users, because our users is also the asset of the company. What I did is I always make sure in every partner around the world, when they ask about, hi Antonius, are you GDPR compliant or not? I will mention to them that Indonesia have a scattered data protections laws and regulation. However, I'll understand what your issues. We have the similar values, and we did a lot of the privacy as well, and then we maintain our customer at the top level. If you, maybe one of the Ashutosh or Beatriz.
I think your main concern is that you have certain problem with some Facebook feature, and when you complain about that, Facebook turn around and say that you have consented for it.
No, see, my question is, the other answer which they gave is, it is a machine-generated thing, or it is a machine automated feature of Facebook. So if we leap into artificial intelligence, which is predictive analysis or predicament of something, who holds the liability in that case? Facebook or that machine or the artificial intelligence technology? My privacy is breached, that's a different thing, but to whom to call upon for? You know, that's artificial intelligence or the machine learning we are heading to.
Yeah, so that's a very interesting question. In fact, I faced a similar question on a different event. And there the consensus was that all these companies were employing this use of artificial intelligence to regulate or do their business. There should be, we should adopt the principle of strict liability, that if your artificial intelligence is leading to some kind of a harm or damages to any citizens or any individual, then you will be liable because you have employed that artificial intelligence, you have enjoyed benefit out of that, so ultimately you will be held liable for that. However, I think when it will come to judicial inquiry or in case, I think the court will look into some evidence of whether the management had knowledge of these kind of practices or not, whether they were aware what their artificial intelligence is up to. In that case, if we have that kind of evidence, yes, the management will be liable. But I think to address your concern, the proper approach will be strict liability. We don't know whether in how many jurisdictions that principle will be adopted. GDPR is also new. India has yet to adopt its new law. We'll see how the court will implement. Hopefully, we'll have more clarity by judicial decisions. Yeah, right to Indian parliamentarians, they are still debating a new law. Maybe they'll take care of your concern. Yeah, so just provide your feedback there.
Perfect. We still have time for one last question. Sure.
Hi,
Hi,
Adil
everyone.
here. I work for Galderma, a pharmaceutical MNC in the region. Mine too is a slight observation, but I'd be interested to hear your feedback too on this. So in the wake of the Cambridge Analytica scandal, we saw Mark Zuckerberg, the founder of Facebook, appear before Congress related to the data, the passing and access of data, Facebook user data, similar to the remark made previously. So my point is, when it comes to the data privacy protections, especially when it comes to MNCs and the responsibility they have, it seems that the biggest fear they have, rather than fines and, as mentioned in Indonesia, maybe even a possible prison term, would be the reputational damage the organization can suffer, both with its users and in trading, and how that financial effect ultimately would deter them and also incentivize them to take better data protection measures and measures for its users generally, especially in the technology and digital platforms. I wanted to know what you thought about in that respect.
Okay. Well, that is the risk if you mislead the data. One of the UK firm now is closed because of mislead of the data. It also happened in Indonesia because one of the political candidates analyzed the behavior of the users online. That's why I'm working for my company who managing more than half of the population of the country. I'm really aware about the risks that we're facing. I really know about the bad impact if we mislead the data. That's why I will try to balance between the potential and then the risk. On the other hand, if we talk about the beneficial of digital data, it will be really a huge potential. I work with a lot of startups in Internet of Things. They do a lot how to scaling up the business of the farmer. They know about how to create and then to reduce the congestion in the city because of the traffic. So if we know how to manage the data properly, and then you know about how to managing, I think it will be great how the regulator and the businesses and also the individuals know about their rights and obligations.
Perfect. We're going to take the last to an exception. Yes, please.
Hi there, my name's Bernadette. I've been fortunate enough to be a general counsel and a head of legal and compliance in both Australia and in this region, spanning over the last 15 years. And in that time, I've obviously worked with IP across end-to-end operations. And it's just occurred to me from something that was just said about the strict liability point, that having worked for a bank and obviously been in a situation where the banks has a fiduciary obligation to its customers to maintain secrecy and privacy, it occurred to me that the big social media entities should not only, that strict liability point should be taken further. At common law, we should have a fiduciary obligation imposed upon them for the important asset of data.
We cannot hear you very well.
Oh,
Yeah.
sorry. Can't
That's
hear me
maybe
clear? You want me to stand? Is that better?
Yeah.
Yeah.
Happy
Can
to
you
take
repeat
this
that
away.
again, please?
I was just saying that liability is
Yes.
a really valid one. That you've got a fiduciary obligation on lots of entities, given the proximity of the relationship between a customer and a corporation. The social media corporations, the size of them and their proximity to the customer should impose at the very least a common law, a fiduciary obligation to maintain the privacy and the secrecy of the asset, which is the data of the customer. I think there's a lot to be said for the law to develop in that space. Yes, we have statutory commitments, but at common law we should be expanding that. That's something that I think could be expanded. Any thoughts on that?
Yeah, I mentioned that because it's something which is fall within the domain of judiciary, where they will have some room to develop this law, develop the jurisprudence on the line of strict liability, and they will feel that there is a kind of a vacuum and there is no particular provision, either the GDPR or maybe in our country the Data Protection Act will have a specific provision to deal with a specific illegal activity or maybe any kind of a mischief. Then they will take recourse of these legal doctrine and may expand the law. And you rightly mentioned about there's a fiduciary relation. That's why in our proposed legislation we have used the term for data collector, data fiduciary, because there is a kind of a trust between the users and the data collector, and that's add to your point as well. You mentioned about the reputational harm. So it's the relation of trust. If a company is known for breaching the privacy of its users, that will drive away the users from that company's organization. So that may affect their business. So yes, it's a fiduciary relation.
Super. I think we're out of time. I thank you all, Beatriz, Ashutosh, and Antonius. It was fantastic. I learned a lot. Thank you for the fabulous questions.
Thank you. A round of
Thank
applause
you.
for them, please.
Thank you.
Thank you so much. Can I request all of you to please have a group photograph? Please let the claps go on, and such wonderful questions. Claps for yourself also, for the audience. You're doing a wonderful job.